Hi, my name is Jatinder. I'm going to speak about the ASIC versus Sono Australia Gas Limited Company. So, in this report, a case named ASIC versus Sino Australian Gas Limited. The case was filed by the ASIC against the director of the company named Mr. Shah at the backdrop of his listing share ASX, Australian Stock Exchange, where the company has raised 13.6 million. The director of the company had tried to take out the enter cash reserved to the China and triggered the suspension. The case was evaluated on the basis of various sections of the Corporation Act listing rules. I bring issue now. The first one is first defend Sino, the company. The second one is the Shah. So the ASIC in the petition, the ASIC has claimed the following. The company had made false claim regarding to the patents that the claim to holding with the Chinese entity. The company had failed to disclose material information in its prospectus concerning the profit against the claim in replacement prospectus. The company had omit circle information concerning the loan agreement director with the subsidiary entity. In the next issue, the company had provided the wrong information concerning the serving contact that claim in the place of the Chinese entity. The company has provided a wrong information to the auditor regarding to Chinese entity. Those ASIC has a allegation that the Shah has failed to discharge his duties and director, whereas section of the Corporation Act 2001. So that's all about the introduction and issues. Now my friend going to discuss about the rules.
Thank you, Jitender. My name is Venkata and my student ID is KAC3262. Now I'm going to discuss about the rules of the case. ASIC has alleged that the company has been in violation of the section 728(1)(b) and 728(1)(c) of the Corporation Act. These sections are applied when company fails to make disclosures. Section 728(1)(c) is applied here. Under the section of any misstatement in the disclosure document or any misleading document can be an offense. Here, further of the case, as per the rules, company cannot offer security if there is any material omission for the document. This is violation of the section 710, 711, 712, 713, 713E, C, D, 714 and 715. Further, if there is any new circumstances that has arisen an account of after filling the document, then the person cannot issue any securities. Further, the case was judged under the section 710, which states that any filled forms must have all the information that is relevant to the investors and their professional advisor. This is required in order to make an information decision about the matter. The extent to which investors and the professional experts to find the information to make information decisions, and to a person who has relevant knowledge and a person who knows that has the information. Further, the case is judged on the basis of listing rule 3.1. It provides that once an entity is or became aware of any information concerning that a responsible person would expect to have a material effect on the price of the value of the entity security, the entities must immediately tell to ASX about the information. Further, the company is also judged on the basis of ASIC 728(1)(a) dealing with the replacement prospectus, which states that a person or a company must not offer any security if there is any misleading statement. That's all from my part, and my friend gonna continue the rest. Thank you.
Hi guys, my name is Jobanjit Singh and I'm going to speak about the applications today. The second rule here is 614(1) and 2, as well as the listing rule of 3.1 that states that company needs to share all the information that could be price sensitive to the market all the time. So here the company has been in the violation of the rule, as can be seen from the fact that Mr. Shah has transferred a sum of $7.5 million from his Australian account to his bank account in China. So this could be a price sensitive information that he was trying to take the entire cash reserve of the company to his personal account in China. So he didn't disclose this transaction for the reason the transaction with the market regulator to provide a loan to China-based subsidiary. Thus, the application of Rule 7281A and C shows the company is in gross violation of these rules as it has been misleading the information of the prospectus. There is a material omission in the prospectus, and the same can be seen from the fact that company has misled the parents with Chinese subsidiaries and has performed profitability of business, and as well as both of these information were untrue. These material were misinformation. Thank you.
Hi, this is Shoaib and my student ID is VSS30388. And now I will continue my part, which is conclusion. And the court has evaluated the case on the basis of the rule under the section 6742, 7281, 2 and 3. The first thing that the court had ruled out was that Mr. Shao has made false representation in the prospectus documents of IPO filing. These false statements were regarding a patent that he had claimed were held by the China-based subsidiary. Further, court observed that Mr. Shao has failed to disclose that company has loan agreement with China-based subsidiary where he is the sales director. Court also observed that Mr. Shao had made misleading and deceiving statement in the prospectus documents with the regards to service contracts. Mr. Shao had claimed that they hold services control in China, and court has also found that he had made the false claim that company has received $3.5 million from the sale of convertible notes. This information was found to be untrue in the court law. Court has also found several counts where he had provided false information to the auditors regarding the China-based subsidiary. He didn't fulfill his duty of disclosures and he failed to disclose crucial information in prospectus. He had also tried to transfer a sum of $7.5 million from his Australian account to the account in China. This money was transferred to provide a loan to China-based subsidiary. The circumstances were such that this loan would not have been recovered. Now that's all from my part. Thank you very much.